Hello friends, this is Sanjay. In this video series, we will cover the interpretation of statute subject from the LLB syllabus of Chaudhary Charan Singh University or CCSU, Meerut. The syllabus is common for both the 3-year and 5-year LLB programs. The complete playlist is available on the Lawment YouTube channel. While I have covered all the topics that are specifically mentioned in the syllabus, I have also included some additional concepts and topics which are required for a better understanding of the subject and also helpful if you are preparing for any post-LLB exams like the CLAT PG, UGC NET or Judicial services. The timestamps for the specific topics as per the syllabus are in the description below. This is part 4 and we will look at the concept of judicial activism. To understand judicial activism, there are 5 concepts that we need to discuss: judicial review, locus standi, judicial activism, judicial overreach, and judicial self-restraint. We will discuss what these terms are and how they are connected. What is judicial review? As you already know, the government has 3 branches: the legislative, the executive, and the judiciary. The legislative makes the law, the executive implements the law, and the judiciary resolves any disputes and also interprets the law. The constitutional framework ensures that there is a separation of powers and functions between these 3 branches of the government. There is also a system of checks and balances to ensure that the different branches of the government are accountable for their actions, and the misuse or the misapplication of powers can be reviewed by the other branches. On the subject of laws, the legislative makes the law, the executive applies the law. But what if the legislative has made a law that is violating the constitution, or the law is going against the principles of natural justice? Or what if the law is good, but the way the executive is applying the law is not correct? Or what if the executive is misinterpreting, misapplying, or misusing the law? This is where the judiciary can come in and review the law and also review the application of the law. And this review is nothing but judicial review. The concept of judicial review is built into the Indian Constitution. Article 13(2) says that the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. In simple words, the Constitution says that the state shall not make any laws that violate the Constitution. Now, what is this state? The state includes all the 3 branches of the government: the legislative, the executive, and the judiciary, because all the 3 branches are involved in the process of making laws. The legislative makes statutes or acts and can also amend the Constitution itself. The executive will use the powers conferred by these statutes or acts and make various rules, bylaws, ordinances, regulations, and also undertakes actions to implement the law. And the judiciary passes various judgments, orders, decrees, and injunctions, all of which are also laws, like case laws. If any of these laws or actions by any of these 3 branches of the government are violating the Constitution or the principles of natural justice, then the judiciary can review them. The Constitution also supports the process of judicial review through several articles. Under Article 136, the Supreme Court can allow the appeal of any judgment, decree, determination, sentence, or order in any cause or matter passed by any court or tribunal, including those passed by the Supreme Court itself, which means that the Supreme Court has the power to review any judgments or any actions even by the Supreme Court itself. Under Article 32, the Supreme Court can issue writs like habeas corpus to protect various fundamental rights. And Article 226 empowers the High Courts with a similar writ jurisdiction as the Supreme Court, but within their own respective jurisdiction, which is usually the state where the High Court is located. And in various landmark judgments, the Supreme Court has held that this concept of judicial review is a part of the basic structure of the Constitution itself, and the legislature cannot amend the Constitution to take away this process of judicial review. What is locus standi, and what do we mean by the liberalization of locus standi? Suppose a person files a case against a builder or applies to the court for some legal relief. The first question that the court may ask is, who are you? and what is your interest in this matter. The term locus standi refers to the legal standing or the right to bring a particular lawsuit or a legal action. Having a locus standi gives a person a right to appear in a court or before any other similar body on a given question. That is, locus standi gives a person the right to be heard by the court. As per this principle, a stranger cannot be permitted to intervene or interfere in a judicial proceeding. Now, the basic factors to determine the locus standi of a person are: does the person have a legal interest in the subject matter of the judicial proceeding? That is the person legally connected to the subject matter of the proceedings? The legal interest must not be vague or remote, which means that the legal interest must be real or actual and not hypothetical. So, the essentials of a locus standi, as per the CPC, are an injury. It can be real and present or an anticipatory injury which may happen in the future. And the injury can be financial, physical or mental, as long as it is not imaginary. Next is causation. That is, the injury must be caused or expected to be caused because of the actions or the inaction of the defendant. That is, there should be a cause and effect relationship between the injury and the defendant. The third is redressability. That is, it should be legally and practically possible for the court to redress the injury in some form or manner. There are two types of locus standi, public and private. Suppose a person is filing a case against a builder about an apartment. If the builder has not delivered the apartment on time or has cheated the person in some way, then the person has suffered a personal financial injury because of the builder. So the person has a private locus standi. Suppose the person is not a buyer but is filing a case against the builder because the builder has encroached onto public land or a public lake, which means that the general public has suffered an injury because of the builder. Then the person has a public locus standi and can file a public interest litigation, that is a PIL. In most cases, the court will intervene or take up an issue only if the person who is approaching the court has a private locus standi. But with the principle of locus standi being interpreted liberally, that is, with the liberalization of locus standi, the courts have intervened in many public issues, even when there is no complaint from the aggrieved parties. This is where the court has taken a suo motu recognition of the issue. Suo motu means on its own motion, that is, without any request by the parties involved. Or the court may intervene on the basis of a public interest litigation or a PIL, where the person or the party approaching the court may not have any direct locus standi on the case. Let us now talk about judicial activism. Judicial activism refers to the proactive role played by the judiciary in protecting the rights of the citizens and in ensuring that the governance operates within the bounds of the law. Now, what is meant by proactive? Well, if the court simply responds to the issues that are brought before it and just limits itself to interpreting the law, then that is a reactive approach because the court is simply reacting to the issues that are brought before it. On the other hand, if the court recognizes the actual issue that needs to be addressed and expands or adapts the laws as required, that is a proactive approach where the court is going beyond the minimum requirements. For example, in the Vishaka versus State of Rajasthan case, the minimum requirement was to address the case on hand. But the court did not just address the case on hand, the court also recognized that there was a broader need to have some fundamental guidelines to address harassment of women at the workplace. And the court formulated the Vishaka guidelines. These Vishaka guidelines were also instrumental in the eventual enactment of the POSH Act in 2013. In the oleum gas leak case, the court did not just address the specific case, but went on to expand the scope of Article 21 to include the right to a healthy environment as a part of the right to life. Similarly, in the Kesavananda Bharati case, the court went on to say that it has the power to review and to strike down any constitutional amendments that alter the basic structure of the constitution. Another good example is the Mohini Jain versus State of Karnataka case. This case was primarily about the charging of capitation fee. Even here, the court not just addressed the issue on hand. It also expanded the scope of Article 21 and said that the right to life includes the right to education. This proactive action by the court led to the addition of a separate article, Article 21A, to cover the right to education, and later on led to the Right to Education Act. So, the process of judicial review is where the court performs its constitutional duty to review the actions of the three branches of the government and ensure that they adhere to the letter of the Constitution. Judicial activism is where the court goes beyond a mere review and a mere interpretation of the laws and actually looks at expanding the scope of the law to implement its true spirit and meet the needs of the society. A judicial review of the right to life would have been limited to the normal meanings and definitions of the right to life, whereas a proactive activism approach led to the expansion of the concept of right to life to include a right to education. Let us now do a quick comparison between judicial review and judicial activism. By nature, review is reactive because the court is reacting to the issue before it and just looking at the letter of the law. And activism is proactive because the court is looking beyond the issue before it and looking at the bigger picture and the spirit of the law. Judicial review is the traditional role of the court and activism is the expansive role of the court. Through review, the courts ensure that the laws comply with the Constitution, whereas through activism, the court is going beyond the strict legal meanings and interpreting the law to achieve a social change. The basis of review is constitutional power that is given to the court, whereas activism is based on the judicial philosophy and may involve the personal views of the judge, because judicial review is a mandatory part of the court's work, but activism is not. The focus of a judicial review to ensure constitutionality of the laws, whereas activism looks at social justice and public good. And like I have explained earlier, for judicial review, the person or the entity bringing the issue to the court should have a locus standi in the matter. Whereas for activism, the court can take cognizance of the issues suo motu, that is on its own accord, and also on the basis of public interest litigations. The concept of judicial overreach is quite easy to understand. Judicial review is where the court is performing its constitutional duties and just resolving conflicts and interpreting the letter of the law. Judicial activism is where the court is looking at the spirit of the law and trying to address the needs of the society by expanding the interpretation of the law. Now, both review and activism are within the domain of the judiciary or within the powers of the judiciary as set out by the Constitution. Because remember, there is a concept of separation of powers. That is, one branch of the government should not step into the domain of the other branches. For example, the judiciary cannot start creating legislations, which is the domain of the legislative, and the judiciary should not get into the implementation of the law, which is the domain of the executive. If the judiciary is exceeding its constitutional powers and stepping into the roles of the legislative or the role of the executive, that is judicial overreach. In other words, judicial activism becomes judicial overreach when the court's interventions are excessive and without substantial legal grounding, and these court's actions start interfering in the functioning of the other branches of the government. How can judicial overreach be prevented? First of all, the courts themselves and the legislative can ensure that there are clear guidelines with regards to where and when the courts can and cannot intervene. There should be legislative clarity, which means that the laws should be clear, comprehensive, and without obvious gaps, so that the judiciary is not required to step into the process of creating laws. Robust public discourse, which means that the legal community, the academia, and the civil society should comment on any actual or potential judicial overreach. Separation of powers, that is, the judiciary should respect the boundaries of its authority and should not encroach upon the domains of the executive and the legislative branches. Checks and balances. The system of checks and balances between the three branches of the government should be strengthened. Judicial accountability, which means that the mechanisms such as impeachment or disciplinary actions can help ensure that judges exercise their powers responsibly and within the bounds of their authority. The most important factor in preventing judicial overreach is judicial self-restraint. Self-restraint is nothing but self-control, which means that the judiciary itself needs to practice self-restraint, recognizing the thin line between activism and overreach. And the judges should avoid substituting established legal principles and precedents with their personal and political preferences. With that, we can conclude this session. If you have any questions or feedback, post a comment below. I will see you soon in the next video. Take care and Jai Hind.